Hello, welcome to Mentoring with the Masters. In this video segment, you are going to be hearing from Larry Smith. He will be discussing with you Courtroom Decorum.
I've been asked to give 4, 5, 6 examples of things that I think might be useful to young lawyers, either that have not been through trial advocacy in law school, or maybe they're a solo practitioner, they don't practice in a big firm, maybe they don't have a mentor within a firm, and maybe they're headed to court for the first time. So I thought I'd give some things that I think would be useful to a lot of different people. One is, when you go into the courthouse, remember that you are representing a client. You're not really there for yourself. So what you do, what you say, how you conduct yourself reflects on that client. You also represent a great profession. So if you show up in a courthouse with a briefcase or a case file, people are going to look at you and you're going to embody to them the system. And that is a responsibility that you should take very seriously. Allow yourself to be nice and allow yourself to be yourself. When you meet people in the hallway going through the metal detectors or walking down the hallway, smile at them. First of all, it makes it an easier life for you, and frankly, you never know if that person's going to show up on your jury or is a judge or court personnel that you'll see later that day when you open the door. Remember that part of your obligation as a lawyer is to treat those within the system with respect. That means regardless of their age or their financial circumstances, their race or religion or gender or sexual orientation, they are all people within the system and should be treated with great dignity. I'd suggest that you smile and you be polite, but you also make friends with folks in the courtroom, including the bailiff and the court reporter, the people who wander about the courtroom, because they're going to, one way or the other, they may very well have conversations with others within the courtroom. Their judgment is trusted and their word goes a long way, so that means that a bad word's going to go against you and a good word for you may go a long way. A quick example of that was I was in a hearing not too long ago where the court reporter, as I was up talking with him before the hearing, we were just talking about the logistical aspects of how and when to get the transcript, and he mentioned to me that he was really upset because his dad was undergoing surgery that day and he didn't know if his dad was going to make it. And I patted him on the shoulder and I told him that, you know, you get the transcript to me when you can and that'll be fine. He got the transcript to me, and his dad was okay, but he mentioned to my staff that my request for a transcript went up to the top of the pile because I was the only person that asked about him or his dad. So you have to remember that these people may be there to do a job, but they're also human beings. They have lives. Third, stand when the judge enters, when the judge speaks, when the judge is listening to you and you're speaking to him or her, or when the judge leaves the bench. A recent example of that, treating the judge with respect and the office he or she holds with respect, whether you happen to like or dislike or agree or disagree with the particular judge before whom you appear. But I make it a point to follow that rule of standing, and usually the judges will, after you stand and show respect for their office and the seal above their head, the bench and the robe that they've been entrusted with the people, they will allow you to sit down and have your argument. But this particular one, after I had stood, the judge didn't offer that I could sit down, and so I would sit down and stand up every time I needed to address the court or the court was addressing to me. It was a long, complicated hearing on discovery, and I realized the next day that my legs were literally sore from standing up and sitting down so many times. But I think when that happens, the judges are not necessarily being discourteous to you. We have to remember that everybody in the courtroom are human and they're not infallible. So the next time I appeared in front of that judge, I stood up, I introduced myself, and when I was ready to argue, I simply asked, would it be okay with the court if I sat down? The court was extraordinarily gracious, and the hearing went just fine. My fourth rule to you would be prepared. Now that doesn't necessarily mean writing it all out and reading it to the judge, because if the judge really wanted to read something, he would have asked for a brief, or she would have asked for something other than oral argument. So be prepared. When you're not prepared, it wastes the court's time, or the court certainly thinks you're wasting their time. So being prepared does mean reading the things you should read, bring the cases you should bring, know the case or the argument that you're making in front of the court. A court can do one of two things when you don't do that. First, they can simply rule against you, or they can suspend the hearing, so you have to do it all over again. Sometimes they become impatient. That can reflect on you or your client or the outcome of your case. On the other hand, if you are prepared as a young lawyer and the court can see that you're trying, you've read, then the court may very well look at it as an opportunity to help bring a young lawyer along. A simple example is, I know of a case recently where a young associate went into court to deal with some things, and she had lots of tabs on her papers, and there's all colors of highlighting that had gone on. She clearly had worked hard to get ready for the court, but she wasn't quite there, and instead of lashing out because she couldn't necessarily answer all of the judge's questions that he needed to ask, he sat her down, brought her around, and sat down at a table and showed her why those kinds of documents were important to a court. He didn't rule on her case, he just helped her understand why it was important, and I think that was very, very helpful to the young lawyer. Lastly, remember that our profession is based on mutual respect and professionalism, and that means you need to be nice to your adversary and to everyone in the courtroom. It doesn't mean that you will leave being best chums or best pals, but you should leave the private edge outside. The folks in the courtroom have seen all of it before, so they don't need the drama. And I think it's a misconception that lawyers are hired to fight in the courtroom. Lawyers are hired to represent the interests of their clients in the courtroom. And I would respectfully suggest to you that more times than not, if you conduct yourself professionally, then your voice will be heard over the rancor of sheer argument time after time. And when you leave proudly. You'll come back again and you will know more the next time. I hope these tips have been helpful to you.